Mm. So I've started the recording. Tulikuwa wapi? Tulikuwa hapa. Formal validity of other wills. Section 16. Notwithstanding the provisions of this part, every will, whether movable or immovable property, and whether executed before or after the commencement of this act, shall be treated as properly executed if its execution conformed either at the time of execution or at the time of the testator's death to the law in force 1 in the state where it was executed, or in the state where the property is situated, or in the state where, at the time of its execution or the testator's death, he was domiciled, or in a state of which the testator was a national either at the time of his execution or on his death. So how have various courts interpreted this part? So Kenyan courts use section 16 to uphold the formal validity. Okay. So Kenyan courts have uphold section 26 to uphold the formal validity of foreign or cross-border wills if the will complied with the law of any of the connecting systems listed on place of execution, status of the property, domicile or nationality measured at execution or death. The fight usually shifts to proof of foreign law and forum or administration mechanics. This is where you have probate abroad and resealing in Kenya. This is not section 11 formalities governing rules. So section 16, a will on immovable and unmovable properties before or after commencement is treated as properly executed if its execution conformed at execution or at death to the law in force in the state where executed, or the state where the property is situated, or the state of domicile at execution or death, or a state of which the testator was a national or at execution or death. Judicial interpretation, Kenyan cases. Recognition principle plus proof of foreign law is required. The High Court expressly noted that Section 16 recognizes wills executed outside Kenya and pointed to the procedural route for proving foreign law, including evidence by a qualified practitioner from that jurisdiction. This was in Re Estate of Rajni Carrier, deceased 2016. So the marking point is that students state foreign will is valid under section 16, but forget the evidence step. Foreign law is a fact to be proved, often via affidavit or expert practitioner. 2. Forum or resealing approach in cross-border estates. In the case of Keton Morjaria versus Melta Akaria 2016, where the deceased died abroad and the will was executed abroad, the court emphasized the practical approach. Take probate in the most appropriate forum, then reseal for assets in other jurisdiction. Forum non-convince may apply. So marking point is that section 16 answers the following question. Is the will formally valid? It does not automatically answer where should probate be taken or how to administer multi-jurisdiction assets. Key takeaway number 3, if you read the decision Amili Derere versus Amina Mada versus and Kenya Commercial Bank 2014, courts treat domicile as a factual issue that may defeat preliminary objections and require evidence. This comes up when parties rely on foreign succession documents and argue domiciliary law governs movables. How do you apply section 16 in an examination situation? Step number 1, identify the wills, a foreign element. Do you have the execution abroad element? Do you have foreign domicile element? Do you have foreign nationality element? Do you have property instituted abroad and another in Kenya? Step number 2, pick the easiest connecting law to satisfy. You only need one of the D, or one out of A all the way to D, commonly one, place of execution, e.g. UK law formalities. If it is a situs in Kenya, situs, Kenyan land, so Kenyan law may still matter for administration and transfer mechanics. Domicile often decisive for movables, so movable property will be governed pursuant to the place of domicility of this person. Then the nationality, useful for dual nationals and change of nationality. Then step number 3, prove the foreign law and compliance. You have expert affidavit or qualified practitioner of that jurisdiction. You have authenticated copy of the will, probate or letters abroad where relevant. Step 4, administration mechanics. So probate in the primary forum, then reseal for Kenyan assets. Courts routinely prefer this where appropriate. So tricky situations where students will miss marks. Scenario number 1, a will is executed in France, relates to Kenyan land, a Kenyan domicile at death. So facts are, testator signs a French will in Paris 2015, complying with French form. He later returns to Kenya and is domiciled in Kenya at death in 2024. He owns land in Kiambu. Missed points, you only need one limb. France at execution may validate formalities even if domicile later changes. So students wrongly insist that it must also comply with Kenyan Section 11 because property is Kenyan land. Section 16 says anyone connecting law suffices for formal execution. Scenario number 2, will executed in Dubai, witnesses not present together. Facts, one witness attests today, the other tomorrow. This is valid maybe under Dubai law. So student applies Kenyan section 11C and concludes the will as invalid. Correct approach is that you rely on section 16A. If Dubai law allows it, the will is treated as properly executed in Kenya. Separate question, how to prove Dubai law? You need expert evidence. Scenario number 3, domicile dispute when it comes to movables. So in fact, we have a deceased who lived 20 years in Belgium. He kept a Kenyan ID and he has a home in Nyeri. So he dies with bank accounts in Kenya and Belgium. Belgium succession certificate is produced. So missed points is that domicile is a fact question, not assumed from residence or citizenship, must be proved. See Amelie Derere decision. So students miss that movables are commonly tied to domiciliary law in private international law analysis. So section 4, scenario number 4, we have dual nationality changes between execution and death. So there is a will executed where testator was Italian only. By death, he is also a Kenyan. So will complies with Italian formalities. What are the missed points? So that we see section 16D allows nationality at execution or death, either will work. Then students forget the either at execution or at death timing flexibility. Scenario number 5, foreign will exist but no proof of foreign law. So facts are that a party produces a photocopy of a US will, says that it was valid there. He does not attach any expert affidavit. There is no probate record. Witnesses are unavailable. Section 16 does not eliminate the evidentiary burden. Foreign law plus authenticity must be proved. This is in Rajni Kanari career on proving foreign law. Students treat section 16 as automatic recognition. That is wrong. Section C, scenario number 6, wrong question, where we have formal validity versus forum or administration. Facts, a deceased dies in UK with UK will. The Kenyan asset is in form of shares or land. Candidate argues Kenyan law must grant probate first because Kenyan asset exists. Missed points is that separate formal validity, section 6, and forum or resealing strategy, often probate in UK and then reseal in Kenya. See Ketan Morjaria. So don't mix formal validity in relation to resealing and forum strategies. So moving on swiftly, we have revocation, alteration, and revival of wills. Read section 17 of the Act. We have will may be revoked or altered. So a will may be revoked or altered by the maker of it at any time when he is competent to dispose of his free property by will. Then 18, revocation of will. Save as provided by section 19, no will or codicil or any part thereof shall be revoked unless done another will or codicil declaring an intention to revoke it, or by banning, tearing, or otherwise destroying the will with the intention of revoking it by the testator or by some other person at his direction. 2. A written will shall not be revoked by an oral will. How have courts treated section 17 all the way to 18? They have interpreted it as a strict mandatory step where a competent testator can revoke or alter his will at any time, but revocation of a written will only happens 1. By a letter will or codicil with revocation intention expressly or by inconsistency, or 2. Physical destruction by or at the direction of the testator with intention to revoke. An oral will or video or voice notes cannot revoke a written will. Section 17 of the LSA Act, as read in verbatim, is that a will may be revoked or altered anytime the maker is competent to dispose of the free property by will. Then section 18 says that revocation only happens by another will or codicil declaring intention to revoke, or B. Banning, tearing, or otherwise destroying with intention to revoke by the testator or someone directed by the testator. Then section 18.2, a written will shall not be revoked by an oral will. Judicial interpretation in Kenyan cases. So let us start with the first one. Letter will or codicil revokes earlier will if it expressly revokes it or is inconsistent. So in the case of re-estate of Ephantus Munyutu Waigwi, deceased 2014, the courts enforced an express revocation clause. The 204 will revoke the 2000 will. A 207 codicil modified the 204 will. Codicils do not stand alone. Okay. Where no letter, will, or codicil or destruction was proved, court held there was no lawful revocation and distributed strictly per the valid will. This was seen in the case of in the state of Mukindia Murebua, deceased 2018. So another angle that you have to take is that we have oral or electronic last wishes do not revoke a written will. This was seen in the case of Kevin, in the state of Kevin John Ombajo 2021, where a video or audio recording could not revoke a written will, plus it failed oral will requirements. The death had occurred outside the 3 months, so the written will was upheld. Point number 3, we have revocation is a threshold issue that may require oral evidence. Where a newly discovered letter will is alleged to revoke an earlier will, courts treat validity or revocation as fundamental and may order oral hearing rather than decide on affidavits. This was in the state of Isha Sai 2022. So how do you apply section 17 and 18? To prove revocation of a written will, you must show one of the 2 channels. 1. Documentary revocation, a letter will or codicil showing revocation intention either through an express clause or inconsistency. Then you can choose channel number 2, physical revocation. We can have a banning, tearing, destruction, plus intention to revoke, and by the testator or someone acting under the testator's direction. And always, oral statements or videos cannot revoke a written will, pursuant to Kevin Ombajo decision. Tricky situations and where students will miss marks. He said on his deathbed, ignore the will. This fails section 18.2. Facts. A written will was made in 2015. In 2024, the deceased tells family, I revoke it, share equally, then dies 2 days later. Missed points is that section 18.2, oral revocation is ineffective. Written will still governs unless revoked under section 18.1. Don't drift into Section 9 oral will unless facts show a new oral will. Even then, it cannot revoke the written will. B. WhatsApp voice notes revoking the will. Double fail. Deceased records a voice note. My old will is cancelled, then dies 7 months later. Treat as 1. Not a valid written will or codicil, and 2. Even if argued as oral, it cannot revoke a written will. Plus, it likely fails 9, Section 9, timing and witnessing. Person Kevin John Ombajo, a decision. Key point number 3, we have letter document exists but has no revocation clause, either implied revocation versus coexistency. So the facts are that in 2010, a will A was drafted. This will gives land to X. Then will B was again drafted in 2018, and this will now gives all my property to Y, but does not mention will A. What are the missed points? Students think no revocation clause equals to no revocation. This is wrong. Inconsistency can impliedly revoke to the extent of inconsistency. Tie Section 18 logic and plead implied revocation. Okay, so in this situation, you can say that there is an implied revocation because the other will has not mentioned will A, and then it is inconsistent with the property distribution. One tends to give all the property to Y, then the earlier one was only giving the land to person X. So analyze a partial revocation. Earlier will may stand for assets not covered or are inconsistent. Okay, so if the other will, the recent will has not covered some assets that had already been issued out in the previous will, then we can say there is a partial revocation to the assets not covered or not showing any inconsistency. Maybe he has reiterated the same assets in the new will, so the same assets are covered in both wills or not covered. So for assets not covered in the new will, then we can say there is a partial revocation to the same. So D, codicil confusion. So codicil alters but does not stand alone. So a will was made in 204 and a codicil was made in 207. Students treat codicil as a separate will and concludes earlier will was revoked. So missed points is that codicil is a supplement to an existing will. It merely modifies and qualifies it. Unless it clearly revokes and replaces, or the authority is waigi. So waigi is the authority. Higher. So will turn up by the beneficiary. We have intention plus agency trap. Facts. Beneficiary finds the will and tears it up after death, then argues intestacy because will is destroyed. Missed point is that destruction must be with intention to revoke and by the testator or someone at testator's direction, pursuant to Section 18(1). Post-death destruction by a beneficiary is irrelevant and suspicious. So F, will is missing, presumption versus proof, students jump too fast. Facts. Will last known with the deceased. After death it cannot be found. Objector claims it must have been revoked. Missed points. We must prove revocation in one of the Section 18 ways or rely on evidential presumptions carefully. Students often conclude missing is equals to revoked without analyzing the statutory rules and the surrounding evidence chain. So G, incapacity at revocation. Section 17, competence gate. Facts. Deceased with severe cognitive decline. Okay, deceased with severe cognitive decline allegedly burns the will, witnessed by caregiver 2 weeks before death. Missing points. Even if destruction is proved, revocation requires competence under Section 17 plus intention to revoke under Section 18(1). Competence is a separate markable issue. So this is a bit technical. I can reiterate that where the deceased had severe cognitive decline, allegedly burns the will, witnessed by caregiver 2 weeks before her death. Even if distraction is proved, revocation still requires competence under Section 17 plus intention to revoke under Section 18(1). Competence is a separate markable issue. Section 19. Revocation of will by testator's marriage. A will shall be revoked by the marriage of the maker, but where a will is expressed to be made in contemplation of marriage with a specified person, it shall not be revoked by the marriage so contemplated. Kenyan courts apply Section 19 mechanically. A valid will is automatically revoked by the testator's subsequent marriage unless the will expressly states it was made in contemplation of marriage to a specified person. If that contemplation exception is not clearly proved from the will's wording, the will falls and the estate goes intestate or under any later valid will. So Section 19 in verbatim, marriage revokes a will unless the will is expressed to be made in contemplation of marriage with a specified person. Judicial interpretation, we have in the re-estate of late Nicholas Nzioka Ndeti 2018, where marriage after executing the will revokes it unless contemplation exception is satisfied. The court held that a will was revoked by operation of law when the deceased married after making it. There was no sufficient basis that it was made in contemplation of that marriage. 2. In re-estate of John Nikolai Bwire Osogo 2019, the court noted the statutory rule that a will is revoked by subsequent marriage unless made in contemplation of such marriage. Absence of evidence on contemplation supported the conclusion that the deceased did not leave a valid operative will and intestacy applied. How to answer any Section 19 question. To decide if the will still operates, check at the timing. Was the will executed before the marriage? If yes, presumptive revocation. Exception. Does the will expressly state it is made in contemplation of marriage to named person? If yes, marriage does not revoke. If revoked, estate devolves under any later valid will, if none, intestacy. What are the tricky situations where students miss marking points? Engagement is not equal to contemplation unless expressed in the will. Facts. A will is signed in January. Testator marries fiancé in June. Will leaves everything to fiancé but does not say in contemplation of marriage to X. Okay, so missed points is that students argue beneficiary is the spouse, so it must have been contemplated. This is wrong because Section 19 requires the will to be expressed to be made in contemplation of marriage with a specified person. Key takeaway number 2, generic contemplation clause fails specified person. Fact, a will says that this will is made in contemplation of my future marriage. There is no name. Later the testator marries Y. The exception requires marriage with a specified person. A generic clause is a trap. 3. Polygamy or wife disputes derail the revocation analysis. Facts. Will is executed while a person is single. After will, the deceased enters a customary marriage and objector disputes it was a valid marriage. Missed points is that you must first decide whether there was a marriage for Section 19 purposes, often a factual or legal question. If marriage is proved, Section 19 revocation bites unless exception applies. Students jump straight to will revoked without proving marriage. 4. Republication or codicil after marriage. Students forget to check later instruments. What are the facts? Is that a will was made before marriage. After marriage, testator signs a codicil or a new will confirming old dispositions. This therefore says that Section 19 revokes the earlier will on marriage, but a later valid will on codicil can revive or replace dispositions. Students stop at Section 19 and miss there is a later instrument to that effect. 5. Key takeaway number 5. Divorce does not revive the will. Student assume it does. Facts. A will is executed before marriage. Marriage occurs, so therefore this revokes the will. Later, divorce occurs. Testator dies without making a new will. Section 19 speaks only to marriage as a revoking event. Divorce does not automatically unrevoke or revive the earlier will. The estate will be intestate unless another will exists. Revival is dealt with elsewhere. Key takeaway number 6. Marriage is void or voidable threshold trap. Facts. Parties go through a ceremony later found void, e.g. prior subsisting monogamous marriage. What are the missing points is that if the marriage is legally void, Section 19 may not be triggered. Students treat any ceremony or cohabitation as marriage without analyzing its validity or presumption. Then Section 20, we have effect of obliteration, interlineation, or alteration in will. So basically, how have courts interpreted Section 20 is that Kenyan courts treat Section 20 as a strict anti-tampering rule. Post-execution alterations to a written will are ignored unless the alteration itself is executed like a will under Section 11, where it was signed and attested. For typed or printed wills with blanks filed in Section 22 creates a rebuttable presumption of due execution, but only on the filing blanks issue. So, in verbatim, how have these provisions tried to explain? So, Section 20, any obliteration or interlineation or alteration made after execution has no effect unless it is signed and attested as required by Section 11. Signature or witnesses may be in the margin or near the alteration or referenced in a signed or attested memorandum. Section 22. For a type written or printed will executed by filling blank spaces, there is a presumption the will was duly executed. Judicial interpretation. Unattested alterations invalidate the alteration and can seek the old will where execution becomes uncertain. In Francis Mungai Ng'ang'a vs. Hannah Wairimu Ng'ethe 2017, court held a will invalid where it had alterations that were not properly signed or attested as required by Section 11 and 20. Then key takeaway number 2 is that Section 22 presumption applies to filled blanks in typed or printed wills. Challenger must rebut. In Restate of John Moi Kibindia 206, court treated a typed will with inserted particulars, e.g. date, as benefiting from the statutory presumption of due execution under Section 20. Where it is absent, then rebuttal evidence was considered. Then 3. General posture. While there is suspicious circumstances around the document, courts demand strict proof. Even beyond Section 20, courts insist that propounders dispel suspicion and prove compliance with formalities. Kurgat vs. Kurgat Decision 2022. So how do you apply Section 20? First, ask yourself, was the mark or insertion or strike-through made after execution? If yes, it is legally ineffective unless re-executed before true witness attestation and signature in one of the ways permitted by the provision, either on the margin or nearby or a signed attested memorandum. If the will is typed or printed and blanks were filled, apply Section 22 on presumption, but remember it is rebuttable and does not cure other defects under Section 11. What are the tricky situations where students can encounter themselves? Initials next to alterations. So facts of the case are that testator changes 1 million to 10 million and puts initials TM in the margin. No witnesses sign near the change. Missed point is that Section 21 demands the alteration be signed and attested like a will, pursuant to Section 11. Initials alone usually won't satisfy attested by 2 witnesses. Key takeaway number 2 is that witnesses signed the will, but not the alteration. Students assume that's enough. So the facts are that a will has been executed properly. A week later, testator crosses out beneficiary X and writes Y. Witnesses earlier signatures exist at the end of the will. Missed point is that the alteration is post-execution. It has no effect unless the alteration is itself signed and attested or covered by the margin or memorandum mechanisms. Otherwise, the original text governs. Key takeaway number 3, alteration changes the meaning but isn't fatal to the will. Students wrongly invalidate entire will. What are the facts? One clause has an unattested interlineation, rest of will is clean and properly executed. Missed point is that if you check the correct analysis is that the alteration is ineffective. The will may still stand with the original wording unless the alteration creates uncertainty or shows tampering that undermines the whole document. Students often jump to entire will invalid. Okay, so typed will let me send something. In a few. Okay, so alteration. Okay, I was typed will fill blanks filled in by a third party. Section 22 presumption is rebuttable. So facts are that will is printed with blanks for names and ID numbers. Executor admits he filled blanks after death to match documents. So section 22 presumes a due execution where blanks were filled at execution, but admission of post-death filing rebuts the presumption. Now it looks like tampering. Strict proof is required tied to the suspicious circumstances approach in purgatory decision. Another tricky situation is where we have a will has a handwritten date inserted into a typed document. Objector alleges the date was inserted later. Missed point is that you must plead or prove whether insertion was at execution, may be covered by section 22 on presumption per Kibinda decision, or after execution. Section 21 requires signature plus attestation near the change. So the other tricky situation we have, testator writes at the end, I change clause 4 to read, then signs it, and 2 witnesses sign under it, but not in the margin. So the provision expressly allows a memorandum elsewhere on the will, signed and attested, referring to the alteration. This can save the alteration even without margin signatures. So lastly, we have printed will with blanks filled in, but only one attesting witness assigned. So section 22, presumption is about the filled blanks execution concern. It does not cure failure to meet section 11C on 2 witnesses. So before reading section 21, let me send something in a few so that I can focus. So section 21. Section 21 talks on revival of wills. So no will which has been in any manner wholly revoked shall be revived unless than by the re-execution thereof. 2. Where only part of a will has been revoked, that part shall not be revived unless done by the re-execution thereof or by a subsequent will or codicil showing an intention to revive it. Kenyan courts apply Section 21 strictly. Once a will or a clause is revoked, it does not come back by implication, by oral statements, by destruction of the letter will, or by divorce or reconciliation. Revival requires a legally effective act, either re-execution for a wholly revoked will or re-execution of a letter, a will, or codicil expressly showing intention to revive for a partly revoked clause. Section 21, as read in layman, is that a wholly revoked will can only be revived by re-execution. Then Section 21(2) is that a partly revoked provision can only be revived by re-execution or by a subsequent will or codicil showing intention to revive. What are the court's decisions in the case of in the state of Gurnam Singh 2018, where the High Court treated an earlier will as revoked by a later will under Section 18, it reiterated the statutory principle that a revoked will can only be revived by re-execution pursuant to Section 21. Key takeaway number 2 is that in re-estate of Ephantus Munyutu 2014, courts treated a codicil as modifying the operative will and tracked revocation through the instruments earlier will revoked by later will, so codicil attached to later will. These are how revival questions are framed. You must point to a later instrument that shows intention to revive, Section 21(2) or re-execution, Section 21(1). 3. If alleged revoking or reviving instrument is not produced or proved, court will not infer revocation or revival. In the state of Pauline Muthoni Gatu 2020, court declined to treat an alleged second will as revoking the first because it wasn't produced or proved. Distribution proceeded on the proved will. That same logic applies to revival. It must be proved by production plus due execution of the re-execution codicil. So tricky situations and where students miss some mark. Facts. A will was written in 2000. Will B was written in 2016 expressly revoking A. B later found invalid for lack of capacity or attestation. Beneficiaries argue A revives automatically. Missed marking point is that even if B is invalid, don't assume A revives by default. The court will ask what is the operative valid will and whether A was legally revoked and then revived under Section 21(1). Use authority language that revival requires re-execution. 2. Facts. Will B revokes with A. Testator later destroys B with intent to revoke it. Family says A is back. Missed points is that destruction of B revokes B pursuant to Section 18(1), but does not revive A unless A is re-executed pursuant to Section 21. So students conflate revocation of revoking will with revival of revoked will. Okay. 3. Divorce or reconciliation revokes the old will. This is a wrong doctrine. Look at the facts. Will A was made before marriage. Then marriage revokes it pursuant to Section 19. Later divorce occurs. Testator dies without a new will. Divorce does not revive a revoked will. Revival requires Section 21 acts. So students import foreign revival on divorce ideas. 4. Partial revocation by codicil. Later marriage revokes the will. Can codicil revive the revoked clause? Sequence trap. Look at this scenario. Will gives property to somebody X. A codicil revokes that clause and gives the property to Y. Later, testator wants X again and writes a letter to restore X, but the same is not attested. What are the missed points? Is that the letter is not a will or codicil executed under section 11, so no revival under section 21. You must explicitly say that partial revival must be by re-execution or a letter will or codicil showing intention to revive. 5. Republication myth. He kept the old will in a safe, so he intended it to revive. Intention is not automatic to revival. What are the facts here? Earlier revoked will is found in a safe, carefully kept with notes. This is my true will. No re-execution. So courts require the statutory method, section 21, not inferred intention. A note is not re-execution or codicil unless executed as required. Scenario number 6, codicil revoked, clause 4. Letter will C distributes other assets but is silent on clause 4. Student argues clause 4 is revived. Missed points. Section 21(2) requires a letter will or codicil showing an intention to revive the revoked part. Silence is not enough. Lastly, we have testator signs the old will again, but only one witness signs. So what are the missed points is that revival by re-execution means fresh due execution. We must see the signature, we must see the two witnesses under section 11, otherwise the revival will fail. If you read section 22, this is merely on construction of wills, and it tells us that wills shall be construed in accordance with provisions of the first schedule of the Act. So we will have a look at the first schedule of the Act, but there are some tricky situations where I wanted to highlight on, where you have been given a specific gift versus a general residue. So students wrongly give everything under all money. So this is the fact. So a certain will says, I give my 10,000 Safaricom shares to A. Later, I give all monies in my bank account to B. Shares are sold and proceeds deposited into the bank before a death. So students' missed point is that argue that proceeds remain tied to the specific bequest, shares or proceeds, rather than becoming a general bank monies, depending on wording. So there is a reasoning that was highlighted above, and this begs us to have a look at the judicial interpretation so that we can understand. So in the state of Vera Shah 2019, so the court held proceeds of a sale of a specific assets were governed by the specific bequest clause on shares or proceeds, not swept into a general gift of monies in my bank accounts, and reaffirmed first schedule rules. Intention is paramount. Last clause prevails if irreconcilable. Express bequest not controlled by inference. So another judicial interpretation that we have to take note is that courts will require focused submissions where construction is determinative. So in the estate of Jacob Gishunge Muchiri 2019, so courts will require focused submissions where construction is determinative, where courts deferred decision and directed parties to address meaning of a clause on mandatory signatory to a bank account, recognizing construction can decide the application. So courts merely interpret and does not override. Courts reiterated the interpretive approach where they give words their ordinary meaning, read the will as a whole, and avoid remaking the will, though separate statutory intervention for dependents may still apply. So if we are to read now application of specific gifts versus general residue, we say that argue that proceeds remain tied to the specific bequest rather than becoming a general bank monies. So 2, irreconcilable clauses, last clause wins. So students try to average. So there are some facts is that clause 3 says, I give LRX to my son C. Then clause 9 says, I give LRX to my daughter D. Then there is no explanation. The missed point is that identify irreconcilability and apply the first schedule rule. The latter clause will prevail. So therefore, rule number 2 will be the one to be applicable. Point number 3, express bequest versus implication. Students cut down and express gifts using spirit. What are the facts? A will expressly gives a car to A. Elsewhere it says, I want my family to live in harmony and share fairly. B argues the car must be shared. What are the missed points is that first schedule rule number 5, express positive gifts aren't defeated by inference or aspirational language that was seen in Amitral Viral Shah. Key takeaway number 4, meaning of a role versus a gift. Mandatory signatory is not always a beneficiary. For instance, I will state that my brother X shall be a mandatory signatory to account Y. Beneficiaries argue X owns the money. So missed points is that construction point. Mandatory signatory may be administrative control, not as a dispositive gift. Courts treat this as a construction question that can decide the dispute. Key takeaway number 5. Courts interpret, don't rewrite. Students propose fair redistribution under construction. So a will clearly gives 70% to one child and 30% to another. Students argue the court should interpret it to mean equal shares to avoid unfairness. Under section 22 and the first schedule, courts interpret clear words, it does not rewrite. Alexander Werimo peer decision. Any fairness correction is a separate application on e.g. reasonable provision and not on construction of a will. Kenyan courts treat the first schedule via section 22 as a binding hierarchy for will interpretation. Read the whole instrument to find intention, give words their original meaning, prefer an interpretation that makes a clause effective and avoids interstice, and only fix the text, okay, where the context makes the error obvious, not to pursue a speculative fair outcome. So section 22 of the Act, wills are construed in accordance with the first schedule rules set out in paragraph 1 all the way to 22. Judicial interpretation and how courts usually apply the first schedule is that all will reading. So this is where the all will reading is, we have specific plus general plus irreconcilable clauses. So the latter clause will prevail. If we see the decision of Vera Shah 2019, where the High Court applied first schedule rules, including to read the will as a whole, irreconcilable clauses, and the last provision or clause will prevail. Express gift not controlled by ambiguous letter words to decide whether the sale proceeds of specifically gifted shares fell into a general gift of bank monies. 2 is that construction is evidence-led. Court may require focused submissions or clarification where meaning is contested. A court directed parties to address the meaning of a contested clause, mandatory signatory on account, treating it as a construction question rather than rewriting the will. This was in the case Jacob Muthunge Mushiri 2019. So courts will not validate an unwill by construction rules. Where documents look like minutes meeting resolution rather than a will, courts reject it as not meeting the statutory threshold. Tricky scenarios. Scenario number 1, I leave my shamba at Kijabe to my last born. No title number, no device or bequeath. Students say invalid for lack of technical words. Wrong. Focus is whether intention plus subject can be ascertained. Paragraph number 2, meaning from entire will, irreconcilable clauses, last will prevail. If you have a will that has clause 3 saying LRA number 100 to A, then clause 10 says LRA 100 to B, students try to split the land or argue both take. If reconcilable, the latter clause prevails. Students forget the first limb, attempt reconciliation by reading the entire will before jumping to last clause wins. Paragraph number 3 says, will speaks from death. Specific legacy presumed to speak from execution date. Scenario is one where we have a 2010 wheel. I give my Toyota KBN 123A to X. In 2018, the car is sold and replaced with KDA 999Z. Testator dies in 2024. Missed points is that students assume X gets any car, but a specific legacy is tied to the specific subject. Paragraph 3 provision supports speaking at execution for specific legacy identification. Separate construction from doctrines like ademption. Don't just rename the problem. So then after we have analyzed all this, paragraph 22, we will see section 23 so that we analyze further. Now we are analyzing the rules that form the various construction arguments to various wills. So paragraph number 4 is that negative words don't exclude intestate here without a positive gift over. So a scenario is that my son P shall get nothing from my estate. There is no residuary clause. So missed point is that students conclude P is excluded. So paragraph 4 says negative words alone don't exclude. You need an actual gift to someone else to displace intestacy. Okay, paragraph 5. Express gift not controlled by reasons or ambiguous letter words. Scenario is that a person says that I give a Larry number 50 to A, absolutely, because A cared for me. Letter clause, I hope A will share LR 50 with my other children. Missed point is that students treat hope as a binding modification. Paragraph 5 protects the express gift. Reasons or letter ambiguity usually won't cut it down. Paragraph 6, implication only where no express disposition. A scenario is that a will expressly gives a land to A. It is silent on rental income from that land corrected after death. Missed point is that students imply as trust or split income despite an express disposition. Paragraph 6 blocks implication that controls an express gift. Paragraph 7, words may be supplied or rejected. Clerical errors corrected only if warranted by context, not conjuncture. So a scenario is where I give my house on LR 12 to my daughter Mary, but deceased has no daughter Mary, he has Mercy, and will elsewhere calls her Mercy repeatedly. So students either refuse correction, courts can't change anything, or rewrite freely. Courts will assume Mary means Mercy without contextual anchor. So paragraph 7 allows correction only if the mistake is obvious from the will's scheme. Then paragraph 8 all the way to 11 is on technical or ordinary meaning, consistent meaning of repeated words or extra words presumed to add meaning. So for instance, we have a will uses issue in one clause and children in another, lawful issue appears once. So students ignore internal consistency rules pass on to paragraph 10, and the presumption that extra qualifies lawful add meaning to pass on to paragraph 11. They also forget paragraph 20 below, which redefines child unless contrary intention. So paragraph 12, where we have choose meaning that makes clause operative. So scenarios where I give 500,000 to my nephew John, but there are two Johns. One interpretation makes gift impossible, the other makes it workable. So missed point is that students pick the literal ambiguity equal to void root without applying paragraph 12, prefer operative meaning. Then paragraph 13 is where we give effect so far as possible even if full intention can't be achieved. Scenario is where I give my Nairobi house to A and B jointly. If either objects, the house goes to C. A has died before testator. Okay, so A has died before the testator. Missed point is that students declare whole clause fails. Paragraph 13 pushes partial effectiveness to the extent possible, subject to other doctrine, e.g. lapse. Paragraph 14, don't strain construction to validate, but prefer valid construction where two are available. Scenarios where we have a clause could be read as either a valid outright gift or invalid remote gift. Both readings will be plausible. So students jump to court with twist to save it not allowed, or cuts must invalidate also wrong. You must show two plausible constructions first, then pick the valid one. Paragraph 15, we have absurdity or inconvenience isn't a ground to vary and be unambiguous words. The testator gives entire estate to a distant friend. Children get nothing. Wording is clear. Students rewrite under fairness. Paragraph 15 says clear words stand. The remedy is dependence provision, not construction. Paragraph 16. Don't vary construction by subsequent events, but you can consider execution date circumstances capable of arising later. Scenario we have: Will says my house at Karen. He owed none at execution but intended to purchase. Later he buys one. What are the missed point is that students treat later purchase as changing what the clause meant. Paragraph 16 meaning isn't varied by later events, but you can consider circumstances at execution that could arise later. Paragraph 17 presumption against intestacy. Scenario is where we have a will gives several specific gifts but no residue clause. There is leftover property. What are the missed points is that students conclude automatic intestacy for residue without exploring whether a plausible construction avoids intestacy under paragraph 17 while staying within paragraph 14 and 15 parameters. Paragraph 20, child or issue includes illegitimate children unless contrary intention. So a scenario is where I leaves property to my children, deceased had 2 children in marriage and one acknowledged out of wedlock. Missed points is where students exclude the out of wedlock child automatically. Paragraph 20 points you to LSA 3, section 3 2 all the way to 3 to include unless contrary intention appears. So that is various languages that have been used to interpret or construct a will. So the next part is where we have various principles that govern the wills. We have failure of dispositions. So failure of testamentary disposition. Testamentary dispositions or testamentary gifts and dispositions shall fail by way of lapse or redemption in the circumstances and manner and to the extent provided by the second schedule. So I believe this will be the last section. Then we will take over to the next doctrine known as election so that we don't confuse these doctrines. Then we will start over with civil litigation, then go to criminal procedure. Then I've also analyzed criminal, civil, probate. We are almost there. Then we'll go to I've started company, partnerships, mergers, LWD is a practical angle, drafting, amending legislations, past papers. Okay, we are on track. So I'll finalize with this doctrine known as failure of disposition. So this is actually not a doctrine, this is an explanation. So courts treat section 23 as a fail-safe rule. If a testamentary gift cannot take effect because 1. the beneficiary is not alive or eligible at the testator's death, for instance there is a lapse, or 2. the specifically gifted property no longer exists in the estate at death, redemption, then the gift fails to that extent under the second schedule without necessarily invalidating the entire will. So section 23 of the Act talks about gifts and dispositions may fail by lapse or redemption as provided by the second schedule. So section 23 basically tells us that a gift may fail by doctrine of lapse and doctrine of redemption. So redemption, a specific gift fails if the subject is gone or substantially changed at death. So a gift of a land parcel failed by redemption where the deceased had subdivided or disposed of it before death, so the original parcel ceased to exist. This is an example of failure by redemption. Eunice Mumbingathe versus John Kamande Kimani 2012. Then you have another situation, Jidraf Gadhura Githinji, 2019, where property specifically bequeathed did not belong to the testator at death, the gift failed by attemption, but the rest of the will remained operative. Okay, so another situation is where you have a property that is not belonging to the testator at the time of death. That gift will fail by attemption. Another situation is where ademption requires a substantial change, not a nominal or technical change, and executors must still implement the will unless ademption is proved. Point number 2 that you need to take away is that lapse on lapse, gifts to a person who predecesses the testator fails unless will shows contrary intention. So courts have stated that the lapse principle, so bequest to persons who predeceased the testator lapse unless the will indicates a contrary intention to A, but if A dies to A's children or house. In real estate of Chief Stephen Mashembe Waka, 2019. Key takeaway number 3 is when a gift fails, courts often treat the failed subject as failing into residue or intestacy depending on the will. So courts held properties not covered by the will could not be introduced via rectification and had to be handled under intestacy. It also addressed ademption where the specifically bequeathed parcel had not subdivided or changed. This was in the real estate of John Ngige Karungu. So how do you analyze any Section 23 problem? Identify the gift type. Is it a specific gift? My LRN number, my Toyota KBN, then it can suffer ademption risk. If it is a general or residual relief gift, for instance, cash 1 million, or then later refers to all my property, usually not deemed in the same way. Then apply failure mode. So, lapse on lapse when it comes to beneficiaries not alive, qualified at testator's death or no substitution clause, then the gift will fail. Then if on adoption, you have property not in the estate at the death or substantially converted, gifts fails to that extent via adoption. So we then decide destination of the failed gift. If there is a residue clause, failed gift typically falls into residue. Okay. Then, if no residue clause or gift is itself residue, the failed gift may go to intestacy for that portion. This was seen in John Ngige Karungu decision. So what are the tricky situations where students will miss marks? Subdivision is not always ademption. Substantial versus nominal change must be shown. We have scenarios where will gives LRX to A. Before death, LRX is subdivided into X1 and X2, but both remain registered in the testator's name. Students automatically say addeemed. Correct is to say that ask whether the change is substantial and whether the gifted subject can still be identified and implemented. If substantial change analysis is in dirty decision, compare subdivision or disposal in unis bigger there. Then scenario number B. We have sold the property plus unpaid price. Student means the what remains in the estate point. Facts are that a certain will gifts plot Y to B. Okay, so before death, testator sells plot Y. Okay, so as a gift has gifted plot Y to B, but before death, he has decided to sell plot Y. Transfer was not completed. Balance of purchase price remains unpaid. So students say that gifts fails completely. The correct position is that the land may be redeemed, but the right to the unpaid purchase money may still be part of the estate. So executor's duty depends on facts and terms pattern in dirty decision. So gift to A lapses, but will intended A's house. Intention defeats lapse. So what are the facts is that a will says, I give 5 acres to my wife W. W dies before the testator. Will elsewhere refers to W's house to retain the 5 acres. So students stop at W, predeceased, and say lapse. The correct position is to analyze whether the will shows a contrary intention or substitution. So another situation is where we have no residue clause equals to partial intestacy. Students forget to conclude distribution of the failed subject. What are the facts is that a will contains only specific gifts. One is a deemed or lapse, no clause for residue. So students identify a lapse or redemption but don't state where the property goes. Marking expects there is a failed portion, then it goes to intestacy. So this was seen in John Ngige Karungu approach to property not covered by the will, and then the intestacy route was used. If you read key takeaway number E, trying to rectify a will to add assets, this is a wrong approach. After confirmation, executor discovers an extra parcel not mentioned in the will and tries to add it via rectification or variation as obvious omission. What is the missed point is that students allow it. Courts say you can't use rectification to introduce new property into a tested estate. It's dealt with under intestacy if not covered. John Ngige Karungu. F. Redemption does not invalidate the will. Facts. One specifically gifted asset is gone at death. Objector argues the will is invalid. Redemption only knocks out that gift. The will remains valid for the rest of the properties. We are seeing Draft Gadura Gidingi. So up to this point, I end the third session, so that we will resume pursuant to section 24 and analyze all the way to provisions for dependents. We will also see situations where students confuse when it comes to provisions for dependents. I've also incorporated some decisions. We'll also see interpretation of section 27 all the way to 28. We'll also have a look at who is a dependent, who exactly is a dependent. This is a very confusing part. Many students have misapplied this part. Many have misapplied that part. We have gifts in contemplation of death, pursuant to section 31. That is also a highly tested situation. I've incorporated some decisions to the same. Then what do we have to? We have intestacy provisions, where some land parcels have been excluded from application of section 40 on intestacy. We have various situations where an intestacy has left one surviving spouse, child, or children. This is also a highly tested angle, where you can even be told to draft some applications for reasonable provisions, etc. We have also seen interpretation of section 36 and how students usually confuse between section 35 all the way to section 38, 39, and 36. That is a confusion that arises there. We see powers of spouse during life interest, what they can do, where consent is required for transfer of immovable properties, where consent is required from adult children of transfer of movable properties. So those are the marking points where intestate was polygamous. How do you count the unit? How do you apply in an exam situations? These are the marking schemes. Property devolving upon child to be held in trust. When you have a situation that have children as beneficiaries, that state should form a trust. Previous benefits to be brought into account. We have survivorship. How does survivorship happen? Okay, then basically we have covered the substantive parts, because the last provisions are procedural and they will send us to probate and administration rules to be read together. So I can say that we will resume. I have directly gave a light to the conflicting areas and sections where students are confused. Failure of testamentary dispositions has been covered under section 23. We have seen situations where adoption and lapse can be applicable and where students confuse between the two. So we will analyze the act substantively. So thank you. Let me end the recording and upload this session to the YouTube channel. JJ umelala? Oh, korada.